Welcome to the Rosen Dental Transitions podcast, the show featuring success stories and best advice about buying, selling, and managing a dental practice. Now here's your host, the managing partner of Rosen Dental Transitions, Dave Miller.
Hello, everyone, and welcome to another episode of the Rosen Dental Transitions podcast. Back by popular demand, we have Jon Eskow from the Eskow Law Group with us today. Jon, thanks for joining me.
Absolutely thrilled to be here. Thanks for having me again.
We were just talking about, I don't know why we decided to have this podcast. I mean, you may not be listening to it at the end of a month, but we have decided to record it at the end of a month, which is dumb because we both have closings and we're, luckily this, for our clients, this is only 40 minutes out of an entire week. So we are not neglecting your deals because of this, but the stress that we have while doing this is probably higher than it should be.
We did talk about a couple of the closings in the lead into this podcast, and then after it, I'm sure we'll keep talking about some of them and try to make some deals happen.
That's true. Yeah, so that's good. So, and with all of that in mind, the reason I wanted to have Jon back on, because, we've, since the last time we had you on, probably a year ago, we've had a number of shared clients and transactions we've worked on together. And I think one of the things that comes up, especially on the buyer side, because they've never done it before, is just understanding the process and what happens at each stage and, prioritizing the different things that happen in a deal. Because I think sometimes everybody tries to do it at the front and other people wait to the last minute. And sellers have the same issue because they haven't gone through this 100 times, or if they did it, maybe it was 30 years ago and it was once and it was a handshake deal with no attorneys involved. So, that's kind of the thing I really want to focus on this episode, and we can let this go wherever it goes. But what are your thoughts on that? I mean, just that statement, I guess, that just a lack of understanding can really turn things sideways.
Yeah, I think people look at it very linearly, and probably too linearly, right? Like, now it's time for me to do due diligence. Then it is time for me to reach out to the landlord if there's a third-party landlord for the real estate. And only after that point should I then be giving notice to my prior employer. And then only after this point should we be entering into legal contracts or whatever the different phases are. I think for a deal to be done right and to be as smooth as possible, I think the best way to look at it is a little bit more holistically, and to have people involved in the deal who can kind of run down those various paths in parallel, right? And for instance, there's no difference at the beginning. It's not like there should be a diligence period and then legal gets involved, right? Legal should get involved at the same time as you're doing your diligence, at the same time as you're reaching out to the bank, as the same time as you're kind of putting in a plan to let your prior employer know, because that will then enable things to move more smoothly and enable the different people who need to be involved in the deal and involved in decision-making weigh in on some of those pieces, right? There's certain things where we can add value on the diligence side, but if we're not involved, then there's nothing we can do about it.
Yeah. And for every dentist that's listening, it's funny because I'm sure patients oversimplify what you're doing for them when you're treating them, right? And they probably say, I can't believe a crown costs that much, or I can't believe this procedure costs that much. And they tend to oversimplify what it takes for you to deliver great care. And we encounter that as advisors, right? As a broker, we often have people say, well, I'll just do it on my own, or I don't want to pay the fee because, and honestly, I wish it was easier. I wish this process was easier, but it can be incredibly complex. There's multiple parties involved that have different interests. They could be completely unrelated to the transaction, such as landlords, or they could be unknown advisors to buyers or sellers that no one is aware is behind the scenes giving advice. There's just since we're in the fall, a cornucopia of different risks and pitfalls and challenges and things that could come up. And so that was a long-winded way of saying that it's a it's a lot harder than it looks when you just say, I'm going to sell my practice. I think people think of it almost like, oh, it's like selling a house. Like, oh, we'll just put it on the market, we'll get an offer, and then we'll sell it. And it's like,
for sure. And maybe there's a 1% rule, right, where it is that easy, but I don't think that that's the way it typically works out. And I think a lot of people look at what the product is, more than how the sausage actually gets made, right? Yeah. So for us, it's like we have clients who come to us all the time and they're like, yeah, you just like put the contract together, right? And it's like, well, that's an output. Yeah. That is a thing that happens. But there's a whole host of other areas of value that we provide from a project management standpoint, from a practical and just market knowledge standpoint, and helping coach clients through the various kind of questions that come up. And so I think that at the end of the day, a lot of it is just understanding a little bit deeper into the different kind of, value that's being provided, not just the output.
Yeah, absolutely. Well, so let's try and maybe break this down in steps. And I think, John, your point earlier was that this is not necessarily linear. There is a, order in which this might go, but once you hit different milestones, multiple tasks and kind of, workflows kind of happen in parallel, right? Like it's more of an ecosystem than it is a straight line.
Yeah. And maybe there's a beginning, middle, and end, right? But there's multiple things that happen in the beginning, the middle, the end, as opposed to 1, 2, 3, 4, 5.
Yeah. Yep. So if we, and we'll look at it it makes sense, I think, to look at it from the seller and the buyer perspective. The first step is, a practice goes on the market. And from the seller perspective, from where we're sitting, we put the valuation together. We check in with the seller to say, here's what we think it's worth. Here's what we think we should sell it for, because those two could be two different numbers based on the market dynamics. And before we put it on the market, we would recommend that you start to speak with an attorney, so that if we start getting offers, you have someone you trust that can evaluate, the opportunities and what may make sense. Is that the timeline you guys recommend as well? Or when do you think, you should be involved, or it makes sense for sellers to start talking to attorneys?
I think what you described is exactly right. I mean, the first question we ask our seller clients is, what are you trying to achieve from this transaction? What are your goals? We use the phrase North Star. What is your North Star in this transaction, right? What's important to you? And so some people will say, spending more time with my kids, or, living full time in my lake house in New Hampshire, or whatever it happens to be. Or it could be reducing the administrative burden in the day-to-day operations of the practice. Now, we can't evaluate a letter of intent or a term sheet, whatever word you want to use, from a legal standpoint if we don't know what that North Star is, what that background is, right? And so if we get involved and it's just like shoving letters of intent in our face or term sheets in our face, we can't do the actual guidance to make sure that the deal that you're signing up for as a seller is actually going to achieve what you're looking to accomplish. Now, obviously, that's a big part, Dave, of what you guys do, right? But it's good you guys look at it more from a practical business standpoint. We can then look at it from, hey, here are the words on a page. Here's what the obligations are that the seller is being asked to do. Does that check out with what the seller's North Star is, what the goals are for the transaction?
Yeah, and it's funny, like as we're talking about this, it makes me want to have more conversations earlier, because our message to the sellers is that you can really dictate the deal and the structure, or you should dictate the deal and the structure, because there's usually multiple options in the market depending on your scenario. So we want to know all of those things too. And so having an extra layer of someone to say, to make sure that things haven't changed or that we didn't miss something, it's great to have that conversation with their attorney so that we can collaborate and say, hey, we're going to the market with this story. Does this match what you're hearing as well?
Yeah, or what would you suggest maybe we include or not include to help kind of back up that story? I'll tell you, there are not that many transactions that happen where people don't feel really good at the end of the day from both the buyer and the seller side. Because at the end of the day, we're in the business of putting two people together who want a deal to happen. Usually it's a buyer who wants that practice and a seller who's made the decision to sell that practice to the buyer. Now, when things fall apart, and it does happen sometimes, when people have issues after closing, it's almost entirely because there's some sort of misalignment between what a buyer's goals are and a seller's goals are, right? Whether it's the seller wanting to stay longer, right, and being more involved, and the buyer wanting the seller to be less involved and stay less, or whatever that kind of misalignment is, that's where you really run into issues after closing. You know, it's not all the other stuff that you hear about.
Yeah. Yep. It's someone told me a while ago, and it sticks in my head about everything I do when talking with customers, is people are only upset when their expectations aren't met. Right. 100%. And it's like the shining example of this is a good hostess at a restaurant. You go to a restaurant and you walk up to the front and they say, well, it's about a 30-minute wait. If you get your table in 28 minutes, that hostess is a hero. If you get it in 15 minutes, you're going to have a great dinner. But if you get that table in 38 minutes, it's like, oh my gosh, I can't believe this. You know, it's been, when did we give her the name? You know what I mean? Yeah. You spent, once it hits like 25 minutes, like, I'm going to go check in and see if, you know, so you could get to your seat, and, you know, the better example would say, all right, you get to your table 30 minutes from when you walk up. One hostess says the wait's 15 minutes. The other one says 45 minutes. Right? The hostess who said it's going to be 45 minutes to get the table is the better hostess, because your expectations were to wait 45, you get in 30 minutes. And so that same thing exists with buyers and sellers and communication, and the advisors is, you know, what are the expectations of each side, and are we articulating them clear enough? And if their expectations are unreasonable, are we having those honest conversations to say, I understand you want this, but this isn't reasonable within the market, or it is highly unlikely that a buyer or a seller would be open to doing this, things of that nature.
Yeah, I mean, we talk a lot at our firm about, you know, I mentioned project management before, but we talk a lot about at our firm about active project management versus like passive project management, or like active involvement versus reactive, or proactive versus reactive, I should say. And when you're proactive and managing a deal and helping set expectations, people know what's to come. If you just sit back and you let, you know, to use your host example, if that host, let's say they said 30 minutes, right? And if that host comes and approaches me at 20 minutes and says, hey, you know, John, just so you know, there's a table that's finishing up. It might be about 35 minutes total, right? But I just wanted you to be aware that that's, you know, what's happening right now and it's coming. I'm going to feel a whole lot better than if that host is just sitting up there, you know, doodling on their little, you know, table sheet. And then I have to walk up to them at 35 minutes and be like, what the heck's going on? Right. And so I think there's a big piece, and you see it on your end in terms of you working with both the sellers and the buyers from just a transaction guidance standpoint. We see it from the legal side. Like, we want to be out in front, proactively setting the expectations, proactively changing things as deals evolve, to make sure that people are always feeling like they know where things are in the deal, so that there's no frustration.
It's so funny you say that, because I just had that happen this morning. And I think the younger, less mature version, because I'm still immature a little bit, but the younger, even more immature version, well, I had a client who we waited on them for a long time, and we're working for them, so that's fine, right? I tell clients all the time, we're on your timeline. But then when we received the information, it took us some time to work through it, and I didn't do a good job of updating them. And so they kind of got a little frustrated. And my knee-jerk reaction was, you know, we waited 6 months for you to get your stuff in, and now I'm a week late and you're, you know, reading me the riot act. But in reality, like, that was what the younger version would have said. Like, at this point in my career, you know, it's, you know what, they're right. Like, we should have communicated better. We should have had that conversation and say, listen, you know, we're working through this. We apologize. It's going to take about another week or so.
Yeah.
And it would have been a 5-minute conversation. They would have probably said, I completely understand, that's okay. But the absence of communication leads to that, oh, well, did they forget about me? Or, you know, or where am I at on the list?
Or better yet, they could have said, if you had gone out with that, hey, there's this funky financial component of your deal that we're trying to work through, it's going to take us about a week. they could have come back and said, totally understand, but because of XYZ reason, I actually really need this by Thursday. Is there any way I could get it for Thursday? And then you probably would have said, yes, we can move some things around, we can prioritize it and get it to you by Thursday. But not having that conversation in the beginning, that proactive communication, didn't even enable that conversation to happen from your client to say, I needed it by Thursday. And then you've just got people who are frustrated all over the board.
Yeah, and it's funny. I know we're off on a tangent, but I love this because the applications of this principle go to every aspect of business. I mean, I think people right now that are struggling with staffing retention, it's a similar problem. They're just, you're not having conversations with your staff to check in on them and see how are you doing. And I know we've been busy and we haven't sat down in a while, and like just taking them to lunch and giving them the chance to voice their frustrations or to share ideas about how the practice could be better, or to just check in on how they're doing personally, because there could be things, they could love the job, but maybe they're struggling with something at home. And, then it's not the, oh, hey, I'm giving you my 2 weeks, I found another job, right? It could be, the conversation could be, hey, I'm glad we had this meeting. I actually have been frustrated because of X, Y, and Z. It's just that active management of the situation or the business relationship or of your staff compared to the passive reactive approach.
Yeah. And then you end up, when you're being reactive, that leads to whether it's defensiveness or it leads to just the interactions not being positive. Right. And at the end of the day, going back to, dental practice transitions, like the process should be positive, right? Like, both sides are moving toward a decision. Now, it's not an easy decision. There's stress, there's anxiety, there's frustration on both sides, right? But it's a decision that like two willing parties have decided to do. There's a buyer who has decided that this is the next stage in their career and they want to buy. And there's a seller that's saying, for whatever reason, like, this is my time to transition out. So it should be very positive. Right? There is going to be stress and anxiety and frustration. I always say to people early on in a process, like, it's not fun to go through a process of selling or buying a practice. Like, everyone looks at the end result and it's like they think of just, champagne tops popping and like, raucous celebrations, parades, all that great stuff. But the reality is that like getting there is really stressful for both sides. And so at the end of the day, proactive communication, having people involved in the deal that actually know how to manage the process and set those expectations, that's going to lead to the process being as enjoyable or smooth as possible, and reducing, not eliminating, but reducing that stress and frustration and anxiety.
Yeah. So, so if you're listening and you've got all this stuff going on, maybe be a little proactive on something today, right?
Or, better, I always think, I try to make analogies to other parts of my life. It's like, think about how you would like communicate with like your kids or your spouse or your friends, right? Like if you're running late, like I was 5 minutes late this morning, right? I could have just shown up 5 minutes late and Dave probably would have been sitting here saying, where the hell's John, right?
I would have fired a text like, hey, you still coming?
Yeah, jerk.
Yeah.
But the reality is I said, hey, Dave, I'm stuck in traffic. I'll be 5 minutes late. And then that gave Dave the ability to kind of fill those 5 minutes and move forward. But it's all about proactive communication. You can use that in every aspect of your life. It's never a bad thing to do it. And why not use it in the process of perhaps one of the biggest professional transactions that a buyer or seller or dentist is going to have when they're buying or selling a practice?
Yeah, love it. Yep. And so, I think circling back to that process, when you get, so the practice is on the market, right? And if you're a buyer and you're interested, you're going to sign a non-disclosure. You'll get a package of information about the practice that should have, cash flow, financials, practice management information, a profile of the business, probably some pictures, enough so you could see the office and say, okay, is this in the location I'm interested in? Do they accept the insurances? Is this the type of practice that I want to see? That's one question just in terms of like fit. The second thing you should see is what's the cash flow of the business and how much money will I make? Because as an associate or a practice owner, I probably earn a W-2 compensation. And so I need to make sure that I'm not taking some dramatic step back in my life. So that should be the other piece. And then the third factor should be the clinical production. This practice is producing this amount of revenue because the dentist there can do these procedures. If you can't do those procedures, then that could be a major problem for the practice. It may be a small problem, right? They do some endo, it accounts for $20,000 a year. You don't do endo. It's $1.2 million practice, not the end of the world, right? But cosmetic high-end prosthodontist who's doing implants and all on fours and full arches and very expensive procedures, and you don't do any of those, and it accounts for $500,000, well, then that's a different scenario. So I think that's look at Jon is a super smart attorney, but can't figure out headphones.
No, the other one. Yeah, you got it now.
Is it?
People always this is the move.
There you go. Look at that. Oh, look at that. Oh, and also while we're in this break, be careful about tapping the table. You're good, but
Yeah, in law school we didn't learn about flipping headphones back and forth.
Stand back 1 second.
Can we get AirPods here next time? I'm really good with those.
boom.
All right, we're still rolling. So
All right,
Perfect.
What you were talking about the various things though of things that a buyer should be looking at. I don't know if this is where you were going, and we can kind of go back to where you're trying to lead us here in a sec. But those things are critical. But to the point you were making before about the process, you don't need to have 100% certainty on those things from day one, right? Like you may not have 100% certainty when you actually buy the practice, right? I think that the point is that you almost want to get enough certainty, or I would say in the lowest level of certainty, to feel comfortable going to the next stage, right? So it's in that first piece. You look at, the pictures, you look at the analytics, you look at the cash flow, and it's like, yeah, like so long as everything else checks out, like I'm ready to now go into a letter of intent and establish exclusivity, right? Which is the most important thing in a letter of intent. It's probably by leaps and bounds, right? Above, everyone thinks, purchase price or closing date or what's the non-compete. Those are the important things. No, as from a buyer's standpoint, the most important thing is exclusivity. You want to make sure that as you're continuing to look at the numbers, verify that this is the practice that you are going to be successful in, you got to make sure that the seller isn't out there able to kind of accept other offers and, walk away from your deal. You want to establish that exclusivity. So it's really about, at the end of the day, Dave, you want to get to the point where you have as high verification on those components, those three components as you mentioned, but it's not all up front. It's not all at once.
100%. And that's where I think it's like that. So that the goal of that package is for you to have a comfortability that you would be willing to move forward, assuming that package is accurate, right? Everybody wants to, verify that that's there, but you don't do that before you've submitted an offer, and you're verifying kind of the surface level information and looking at like I said, it's kind of the production categories and just making sure that you could step into this office. And I think sometimes people want no risk in the deal, right? They want to eliminate every possible risk in the transaction, and that's impossible. There's going to come a point where you have to have the confidence in yourself to solve whatever problems exist on the other side to move forward with the transaction, because there's never going to be a point throughout the entire process, as we talk about, having your offer accepted and due diligence and legal negotiations, you're never going to eliminate 100% of the risk.
And there's also real risk and there's perceived risk.
Yes.
Right? Like real risk is I have a job right now that is paying me money that I actually like. If I'm going to actually close and take over ownership, I'm going to have to give my notice at that job. Like that is a real risk, right? After you give your notice, there's oftentimes no turning back. Perceived risk is, well, I don't want to really get started on getting pre-qualified for a loan because I'm not sure if this is the practice for me. Well, you're still going to buy a practice though, right? And having a pre-qualification and making sure that you're financeable it's not really much risk involved in that. You may not want to do that step because it takes a little bit of time, or you may not want to do that step because in your brain you've told yourself, I'm only going to do this once, I've got an accepted offer, or I'm further along in the process. But there is a difference between real and perceived risk.
Yeah, 100%. And that's as you're going through, I mean, the beginning of the process is the most competitive part. So any of those things you can do to separate yourself and make you a more trustworthy buyer, or more instill more confidence in the broker and the seller that you're going to be able to close the deal and move forward. All of those things go a long way to say, yeah, you know what, I'm willing to put some work into this. I'm willing to take time to do some of these things that are, mundane or boring or frustrating, but they're necessary. People that are resistant to do that, that's always a red flag for us, because we're like, okay, if you're not even willing to get on the phone with a bank for 30 minutes or fill out a form at night on your couch that would take 20 minutes to do to get pre-qualified, then there's no way you're going to get across the finish line when it comes to applying for the loan, closing the loan, getting your legal work done, getting credentialing set up. It is a mountain of work to buy a practice.
Yeah.
So that's a really good point you brought up about the perceived and real, and just getting over some of those things.
Yeah. And you should have a team around you that's able to help spot those different types of risk, right? And sometimes you may think it's real when it's actually perceived, just because of, we've done this almost 1,000 times, right? In terms of practice transitions. So I can tell you where there's perceived or whether there's real risk. And by all means, if there's real risk, let's solve for that.
Yeah. So all right. So someone gets to the point where, you get the package of information, you talk to the broker or the seller if there's no broker involved, and say, I want to visit the office. You visit the office, see it in person, you meet the seller, you're like, wow, this really seems like a good fit. I want to submit an offer. So one thing is, as a broker, some people will ask for droves of information before they submit the offer. And that's really practice due diligence. Think of it, if you've ever bought a home, you submit an offer and then you do the home inspection afterwards, because your offer is, and clarify this for me, because the way we explain it is that your offer is assuming you're going to move forward unless the package is inaccurate, right? Like, you guys told me this was a certain way, and when I inspected it, it was not, right? That's a material difference from what was advertised, essentially. And you're selling me something different than I thought I was buying. Or something changes. It could be as advertised, but something could happen during the course of the process that is material change and that could impact things. But the offer is, you're kind of saying, all right, I'm trusting you guys that this is all accurate, and then I'm going to verify it after we've agreed on terms, because it's not worth the countless hours or dollars that it takes to verify and check and go through all of the nitty-gritty of due diligence if you don't even agree on the price, or you can't even agree on compensation or anything. So can you talk a little bit about, I know you talked about exclusivity. What are the other important things that offers include, and maybe more importantly, like, what does it not include that's handled later? Because I think that's, sometimes people are, and again, I'm rambling, but here I go. They'll say, well, what about this, whatever.
Work in progress.
Yeah, right.
I'm gonna have like 20 cases at any given time. I've got 20 cases of work that still needs to be, or crowns that still need to be delivered after closing. Like, how are we gonna handle that?
Yeah, it's exactly right.
Well, that's something that gets handled not in the letter of intent stage, right? Because it's really, it's kind of like a process of peeling back layers of the onion, right? And each step further in the process.
Are you saying it's like ogres? Are deals like ogres? Because, Dave, if you had this clip right now from Shrek, we'll continue. I didn't mean to interrupt you, but that goes back to how I said I'm less immature. I'm not completely mature.
It's okay. But you're a nice balance, because you also used the word cornucopia earlier, which I'm actually not sure if I had to draw a cornucopia or define a cornucopia that I'd be able to do that. So you've got it going on that end.
Yeah, I know. I have producer Dave bringing up the Shrek clip right now that ogres are like onions, because it's one of my favorite.
Who doesn't love Shrek though?
Yeah.
Right. And especially when you have kids, like young kids, right? You end up getting to watch these movies like so much more than you remember watching them, and it's amazing.
Ogres are like onions.
That's right.
They stink?
Yes. No.
Oh, they make you cry?
No.
Oh, you leave them out in the sun, they get all brown, start sprouting little white hairs.
No. Layers. Onions have layers. Ogres have layers. Onions have layers. You get it. We both have layers.
So just
Onions and ogres and practice transitions.
yeah, you substitute ogres for practice transitions, and I think 90% of that clip pretty much handles everything. We can probably end the podcast now.
I actually kind of want to clip that and use it for like marketing materials or presentations or whatever it is. That's great. I forgot about that.
Just stumbled
that
upon
piece.
a gem. So you were in
It
the
is.
flow, and I just completely
I was in the
disrupted
flow,
you.
and then we started talking about ogres and cornucopias again, and everything in between. So, I think that you had asked. I think you had specifically asked about the different types of things that would be in an LOI or a letter of intent or a term sheet or an offer letter. It's all interchangeable.
Yeah.
And then what would be kind of something that we would push later on in the process? I think the most important things, I'd say there's probably 3 things that I would say are most important in a letter of intent. There's, what are you buying, right? What is this practice, right? Some people have multiple practices. We want to make sure we're allocating, specifying the practice. Second thing is going to be, what's the purchase price, right? There's 0 point of moving forward in a deal if you can't agree on a purchase price. Like, I'll have people come to us all the time and say, well, can we just say like mutually agreed upon? Well, yeah, but then like, what's the purpose? Why are we even doing this?
Yeah.
Right? Like, what's the purpose of a letter of intent if you don't know what the purchase price is and they don't know what the purchase price is, right? And the seller, neither side 100% knows what the purchase price is. And then the third thing I'd say is that's most important is just a general understanding of timing, right? A target close date when you're looking to close. Now, I've mentioned exclusivity a couple times. If I'm a buyer, I would say that's probably number 2 behind purchase price, right? In terms of the most important thing. From a seller standpoint, it doesn't really impact you if you don't have it in there. It's really purely a protection for a buyer to ensure that the seller isn't able to continue marketing the practice to other potential buyers while you're spending all this time, money doing due diligence. Another piece that I would say is a valuable piece to think about from a letter of intent standpoint, and you were kind of alluding to this before, and we've alluded to this throughout this podcast about process and when you kind of do the ogre thing and peel back layers of the onion. It's when do you do due diligence, right? If I'm a buyer and you're saying, Dave and John, you're telling me I shouldn't be doing this in-depth due diligence up front. Well, then when the hell should I? And the answer is, there should be a period of time. Usually I would say about 30 days is appropriate, during which there should be a contingency in the letter of intent where you have the ability to go as many layers of that onion deep as you want. Pull as many reports as possible as you want. Walk into each operatory of that office as much as you want. Talk to that seller as much as you want, right? To get a real flavor of whether this practice is one that you can be successful in. And it's during that time where you can go as deep as you want, whether it's 2 or 3 or 20 layers deep into that onion, to figure out if this is the right practice, right? But to your point, Dave, from before, the idea should be that when you enter into a letter of intent, it's kind of past I'm not a huge fan of the home buying analogy because I think it's much more complex to buy a dental practice, but using the home buying analogy, right? It's almost like the Zillow test, right? Does this house have, I wanted 2 garages. Does it have a 2-car garage? Yes, it does. Perfect. I want at least 2 acres. Does it have 2 acres at least or not? Okay. You start to check off the boxes and you're like, yeah, I could see myself, this being my forever home as a dental practice that I would continue to own and operate, hopefully for the next 30 years. So long as it passes those tests, then by all means, go forward into that letter of intent, get that exclusivity to protect yourself, and then make sure you've got about a 30-day due diligence period to go and really dive into the numbers and dig into the practice itself. But you don't need to do that before a letter of intent.
Yeah, 100%. And it's, some people are like, oh, I don't mind. It's like, well, yeah, you don't mind. Maybe you have a ton of free time, but the sellers, the broker, everyone else, wants to make sure that we're being efficient with our time and handling this the right way. And so you see this practice and, you don't just, I think the other thing you mentioned, can't we say mutually agreeable? The other philosophy, you should not be thinking, oh, I'm just going to throw out a high number, or I'm just going to throw out a number and then we'll negotiate it later. Like, that is not the goal of a letter of intent.
It's an interesting point you're bringing up. It's, for the most part, letters of intent are non-binding, right? We often get that question. Is it non-binding or is it binding? Am I bound by what's in here? And the answer is, by and large, no, it's not binding, right? If you decide to walk away from a deal and not do it, you don't have to have a reason. You can just walk away from a deal and not do it. But non-binding is not a substitute for, I'm going to throw something out there and plan to renegotiate it later, right? The intention should be, assuming everything checks out, and you said this earlier, assuming everything checks out, I am comfortable moving forward with this transaction on the terms that I've laid out there.
Can you go to a little deeper into the non-binding thing? Because we get this question from sellers, and transactions are, I think, a little unique in the dental industry, and that there's not a lot of teeth to the LOI. Because sometimes, right, we get down the road and something changes, or for whatever reason, the parties, whether it's the seller or the buyer, let's say for this example, a buyer gets along and they get down the road and they decide the transaction's not for them, whatever reason. It could be personal. We've had something where, you know, it's a life event. A spouse gets diagnosed with a disease, a terminal disease, and the buyer says, listen, I can't do this. And not necessarily in that scenario, but like sellers will say, well, do they put a deposit down? Do I get to keep a deposit? Right? And the answer most times is no. And that can be really tough for sellers to understand or to appreciate. So I don't think I'm like sharing any secrets here, but there's not a lot of recourse if a letter of intent does not work out. So I think that's why we think it's really important to vet buyers and to meet them and talk and to make sure that everyone's moving forward in good faith and wants to do the transaction, and no one feels like they're being pulled along or like, you know, begrudgingly entering into the process.
Yeah, no, it's a great point. So to hit the binding piece, usually there's just a couple of provisions in a letter of intent that actually are binding, right? The exclusivity concept, which is, again, the requirement for a seller not to go continue to solicit offers or even entertain offers that may come in after a letter of intent is signed. Exclusivity should always be binding. Another piece that's oftentimes binding and should be binding is confidentiality, right? That everyone's going to keep the terms of this, and the fact that the parties are even discussing this transaction confidential is definitely something that's going to be binding. And then usually the third thing that's binding is some sort of acknowledgement that kind of everyone's responsible for their own legal fees or other costs, diligence costs, other types of things involved in the transaction. Those are usually the three. Maybe there's a couple other things that are binding, but that's all kind of legalese, right? The stuff that people usually get concerned about, the purchase price or a closing date or the way that accounts receivable get handled or whatever it happens to be, those are all things that would be called, you know, non-binding. And what non-binding means, again, it doesn't mean that we'll negotiate this later. It just means that, you know, if you decide to walk away from a deal or if you learn about information that makes you not want to proceed forward with those terms, you're not stuck with it. And I think it's an interesting concept. And there's, you know, you mentioned the piece about recourse. What happens if you've spent all of this time and energy and you know, maybe money, depending on what you're how you've approached things, and what happens if the other side decides they want to walk away? And it's a hard thing, honestly, Dave. You and I have talked about this just in terms of specific deals. There really is no good recourse, right? You can put deposits out there, but because, and they're usually very nominal in the dental industry, $5,000, $10,000, give or take, right? But the reality is that because of the low dollar amount and because of the number of contingencies that need to happen, whether it's you need to get a lease assignment from the landlord, you need to get a loan to buy the practice, you need to do your due diligence review to make sure that the practice numbers check out, deposits are largely, I would say, ineffective, right? Because there's a lot of backdoors for ways to get out of a deal.
Yeah.
And so I think in some ways, though, that really helps. To me, it goes back toward what is your process, right? Who are you working with, right? And how can you make sure that you've got the leadership on the deal to make sure that you're reducing that risk as much as possible?
I feel like sometimes when we get hired, it's doctors that originally said, I don't want a broker, I can do this on my own. And then we hear from them 9 months later and they say, oh, I'm tired of being jerked around by buyers. I would love for you to help me get through. Because someone, there's no kind of understanding of the process or how to set deadlines and kind of to make sure that you're progressing compared to just treading water, right?
Yeah.
Or running in mud or whatever analogy you'd like to use for that scenario.
Well, I mean, you're a seller and you're out there and you're saying, hey, I don't need to pay a broker fee. I can do this myself, right? And then you get a buyer who comes in and that buyer decides that, you spend a bunch of effort pulling all these reports and meeting with the buyer, and then that buyer decides they want to walk away, right? And then you go back and find another buyer. And then it continues to happen. All of it, time is money, right? I mean, it sounds trite and it's kind of it's a throwaway sentence, but look, for a busy doctor who's working 4 or 5 days a week, sometimes even more, and they've got to be there on weekends to show the practice, it can be exhausting to not have it work the first time, right? Or not have it be run in a way that's efficient and smooth, and not outsource a big part of that headache to someone like you on the transaction advisory side.
Yeah. So you get this you get the offer letter signed, right? You get into this process. I think that's where, multiple paths kind of run in parallel. We tell people that there's the legal track, which is the attorneys will be talking together to help work out the contracts, obviously consulting with their clients to get the purchase contract and the lease or real estate on track, whatever that is, whether it's a purchase, a lease assignment, a new lease negotiation. There is the practice due diligence, which is, between the buyer and the seller and usually facilitated by us, which involves a physical inspection of the practice, usually diving into the practice management software, an understanding of all the HR policies, the staff, their benefits, et cetera, a really deep dive into the operations of the business. And then the financial due diligence, which is the buyer getting approved for the loan, right? And I feel like all three of those basically kick off at once after the offer is signed. Is that how you guys typically see it, or what's your take on it?
That's how we'd like to see it. I think that the more effort that everyone is putting into a deal, the more time that the buyer and the seller are putting into a deal, the more money that a buyer and a seller are spending to ensure a deal gets done, makes people more motivated and more thoughtful about actually getting that deal done, right? And so now I think that there's a valid argument to say that the first two things that should happen, or at least the first thing that should happen, is at least the beginning of that deeper dive of due diligence. And I do believe that, right? It doesn't make sense to jump into a binding asset purchase agreement if you haven't done at least one or two deeper dives into the practice to make sure it's the right practice. But as soon as you feel like that's not a hard exercise, usually pretty quickly you can tell this is not going to work, or yeah, this is fine. I mean, I want to do some more research and some more crunching of numbers, but this is kind of checking out. Once you have that initial kind of thumbs up, at that point, in my view at least, it should be everyone plowing forward, right? On the binding legal contracts, right?
Yes.
On reaching out to the landlord, on all these other things. Now, that doesn't mean that we need to move up a closing time frame, right? It just means that we're reducing the stress and anxiety and frustration of trying to cram things down in a linear way, right?
Well, that's what we've built, a 3-page checklist. We try to make it as short as possible, but there's a lot, and it's for a buyer and a seller, and we try and kind of tranche these activities because there's a lot to do. And to your point, there's certain things you want to dive into right away. And if a buyer or seller are unwilling to do that, that's a red flag, right? Of okay, we're trying to get this due diligence scheduled and we can't get on someone's calendar, or the buyer doesn't want to, take this initiative. That to us is okay, well, how invested are you in this transaction? And so I think like having an understanding of, okay, these are all the things I need to do, but let's focus on these 3 on week 1, right? Or week 2. Let's get the in-person due diligence scheduled so we can make sure that philosophically we're in the same realm from a clinical perspective. And I feel like it's a good fit. Both people.
Proactive though, but what you're describing is like a proactive process where you are actively looking at the various kind of streams of things that need to get done and then putting a plan around them. So people have like a path to go down. And I think that makes a ton of sense. And I think that where things sometimes go off the rails is if people try to put, either a buyer or a seller tries to recreate a process that actually has a developed history of how you can make something successful or not, right? And so I think that at the end of the day, the more you can kind of start in parallel makes things much easier down the line, because at some point you're going to run into a situation with diligence where things are going to come up that are more appropriate for like the legal documents, or something's going to come up in the legal documents and the question is going to come, well, where are you in the process of the bank financing, or where are you in the process of the landlord? And so at a certain point you're going to get stuck, right? With things not being able to move forward perfectly linearly. So might as well start from the beginning with having a balance.
Well, this was awesome, John. A 2-parter, right? So we're going to, finishing up part 1 of this episode about the process. Thank you so much for taking the time to join us. John, if someone listening wants to find you, where can they track you down, either website or social or email or whatever you want to provide?
Yeah, so you can go to our website, www.eskowlawgroup.com, www.eskowlawgroup.com, and we'd love to work with you and support you in whatever journey you're trying to go down.
Awesome. Thank you again, John. This is Dave Miller from Rosen Dental Transitions. You can find us on the web and also on social at rosen.dental.transitions.com. Thank you, everyone, and we will see you next time.